If you are thinking in creating an international business corporation, most likely you are comparing jurisdictions: Delaware, Belize, Malta, Wyoming, and of course, Panama. And that is exactly where usually a little discomfort arises. Because for many, Panama sounds familiar, but not for positive reasons. It is that name that appears in articles, conversations, newspapers. It was a scandal that shook the world, the Panama Papers. Even if you don't know exactly what it was, you sure hear about it at some point. And if someone mentions a Panamanian IBC, it is almost inevitable that a little doubt comes to your mind when you hear the word Panama. Now the question is, can that be trusted? And before moving on, tricky questions must be asked. How did a Panamanian legal structure ended up being used to hide billions of dollars without anyone noticing? What exact role did the IBCs play in the Panama Papers? And what changed in concrete terms so this structure can be used in a legitimate, secure, and global scale? It all began in 2016. An unprecedented leak exposed internal documents from Panamanian law firm. What those papers showed was not just a list of millionaires with companies abroad. It was an entire system. Companies created in series, without supervision, without a real commercial purpose, with hidden shareholders and no type of financial reporting. The favorite vehicle to do all of this was the Panamanian IBC, a corporation with great legal flexibility, low cost, and minimal transparency requirements. And although many were used for legal purposes such as trade, investment, or estate planning, thousands ended up in the hands of those who only wanted to hide money. Panama did not invent the problem, but enable it. And when the scandal erupted, the damage was global. But the country that paid the price was only one. From that moment, Panama began a process that very few countries would have had the will to undertake.
De las 800.000 sociedades anónimas que estaban registradas en Panamá, el gobierno deshabilitó alrededor de 300.000. Esto como parte del proceso que lleva al país para mostrar la efectividad en los temas de prevención de lavado de dinero previos a la reunión que sostendrán el próximo 8 de enero con el Grupo de Acción Financiera Internacional, GAFI.
That is right. Panama modified its corporate laws, signed information exchange treaties aligned with the OECD and the FATF standards, and began to require all substance, accounting, and compliance requirements. It is no longer possible to open a company without a clear commercial justification, without identification of the ultimate beneficial owner, or without fulfilling basic obligations. Panama left opacity behind. In 2023, it was officially removed from the FATF Grey List. And in 2025, the European Union announced that the country would be removed from its high-risk list for money laundering. Today, the country that many saw as synonym for evasion is an international ally in the fight against financial crimes. And now that the field has changed, it is time to look forward, because in 2025, IBCs are more alive than ever. Why do thousands of entrepreneurs and global companies continue to choose Panama as their operation base? What tax, legal, and strategic advantages does a well-structured IBC offers today? And how can you ensure that your company is not only protected, but well-positioned to grow in today's global world? A Panamanian IBC is not a trick nor a trend. It is a legal and corporate tool that allows any person and company to operate outside the country where it is incorporated. In the case of Panama, this becomes especially interesting due to its territorial tax system. This means that the taxes are only paid on income generated within the country. So if your company sells services or products outside of Panama, that income is not subject to a Panamanian tax. And this also applies to dividends, interest, and capital gains as long as they come from abroad. It is not about hiding money, but about structuring your business in an efficient and legal way. In addition, these structures are backed by one of the oldest and most stable legal systems in the region, Law 32 of 1927, a law that has proven to work for almost 1 century, adapting to global changes without losing legal strength. Legally, a Panamanian IBC needs at least one director and one shareholder, who can be individuals or legal entities, Panamanian or foreign. There is no restriction on nationality or residence. And the best part is that it's not necessary to travel to Panama to incorporate it. Everything can be done from abroad through an authorized resident agent, such as a Panamanian law firm like us. The standard authorized capital is at $10,000, but there is no obligation to deposit it. It is a nominal figure, useful for dividing shares, but without real financial impact in practice. Full incorporations can take between 4 and 5 business days. There is even an express option for urgent cases. And if what worries you is privacy, it is worth clarifying that the names of shareholders do not appear in public records. Only directors are visible. But even that can be managed with nominee directors, a legal and common practice in which the law firm acts as a public face without actually controlling the company. Private agreement and power of attorney guarantee that control always remains with you. Shares can be issued as registered or bearer. The latter must be legally held in custody since 2013, reinforcing transparency without losing the option of regulated anonymity. All this also under a banking system that still offers professional secrecy, regulated and solid with no improvisation. The only mandatory tax payment to the Panamanian state is a fixed annual fee of $300, as long as the company does not carry out operations within Panama. It is also not required to submit income tax return or financial statement as long as the activity and income are exclusively international. However, the law does require keeping accounting records and declaring their location, although it is not necessary to submit them to the tax authority unless requested. It is a low-maintenance system with no periodic audits or excessive administrative burdens. Ideal for those who want to operate globally without getting tangled in local bureaucracy. And when it comes to assets protection, IBCs remain one of the best tools. You can use them to register intellectual property, manage investments, operate digital platforms, coordinate remote teams, control subsidiaries, or centralize international invoicing. The range of uses is vast, from consulting to e-commerce, logistics, software, real estate, or royalty management, all within an accepted and functional legal framework. Of course, if you are going to operate within Panama, you must register the company with the tax authorities and obtain the commercial license. But if your activity is purely international, that is not necessary. It is enough to maintain the resident agent, keep basic accounting, and pay the annual fees. Simple, direct, and functional. And in this whole process, legal advice is everything. NDM Law Firm & Associates is a Panamanian law firm specialized in creating IBCs with a strategic vision. We do not just deliver papers, we advise you on the design, structure, compliance, and how to make your company function legally and commercial from day one. From opening accounts to maintain the books and legally representing your company. The question is no longer whether Panama is trustworthy. The real question is whether you are taking advantage of all these benefits while others already are. Would you trust a Panamanian IBC today? Would you dare to structure your business with one of the most powerful tools in the global legal world? Let me know in the comments. If you enjoyed this video, give us a like and leave a comment if you have any questions or if you would like to know more about this topic or any other. See you in the next one.